Right, good evening, everyone. Thank you so much for joining us. I'm your chair this evening. My name is Dirie. So what is the seminar or evening about tonight? So what we're covering is that climate change is a significant driver of migration. The aim of the seminar will be to introduce and to discuss the ways in which the effects of climate change might be identified and relied on in the making of protection and human rights appeals. Human rights claims. Our first speaker of the evening is Professor David Cantor. He's the founder and director of the Refugee Law Initiative at the School of Advanced Studies, University of London. He brings a wealth of experience, over 25 years of research, advice and advocacy. And he's going to speak on international protection, disasters and climate change. So without further ado.
Well, a very good evening to you all, and thanks very much, Ubah, for the introduction. So I propose to talk through a couple of areas which I hope will be relevant to this topic. But starting off, thinking about the statistics, it's very well known that disasters linked to natural hazards can be a push factor for displacement and can feed into mobility patterns. For instance, sudden onset disasters linked to natural hazards, such as storms, flooding, volcanic eruptions and wildfires, triggered an estimated over 300 million incidents of internal displacement between 2009 and 2022 worldwide. Meanwhile, slow onset disasters, things like drought and desertification, have also added significantly to human mobility trends. And of course, in the background, unchecked global climate change is likely only to exacerbate these dynamics. In tandem, the risks of harm that people face as a result of disasters and climate change in their home countries are also increasingly raised in claims for asylum or international protection. But amongst lawyers, decision makers and policymakers, I think it's fair to say that a considerable degree of confusion still exists as to whether persons facing these kinds of risks are eligible for international protection, whether as refugees or under human rights law. Before going into more depth on international protection, though, I'd like to just frame some of the concepts and the empirical issues that we're dealing with here. So thinking about climate change and disasters from a more conceptual standpoint, I think our starting point is hazards. And when we talk about hazards, in this context, we're talking about natural hazards, the ones that I just mentioned, things like flooding, wildfires, volcanic eruptions, and so on. And I think an important point to realize here is that we're not just dealing with distinctions between slow onset and rapid onset events. We also need to be careful to acknowledge that natural hazards, whilst they do include climate-based hazards, also include a range of other sorts of natural hazards. For example, geophysical hazards. By geophysical hazards, we're talking about things like volcanic eruptions and earthquakes. And the point I want to make about all of this is that confining ourselves to thinking merely about climate-related hazards risks excluding the wider range of natural hazards that also pose risks to people, risks to life, risks to property, risk of injury, and so on, and which can also be a driver for displacement. So although we're going to be talking about climate-related disasters, remember that there are a wider range of natural hazards out there which may produce very similar kinds of effects. And I think that there's a risk of real discrimination if we focus only on the climate-related ones without looking at the broader range of natural hazards that exist. Conceptually, sitting above these hazards which occur from time to time in particular places, there's this global process of climate change. And I think the important thing to realize here is climate change isn't a similar kind of factor to these hazards. It is, if you like, a background factor or a threat multiplier that sits behind the climate-related hazards and does things like increasing their intensity, increasing their frequency, increasing their unpredictability, increasing their duration in particular parts of the world. So the point here is that when we think about climate change, it's at a different kind of level to the sorts of risks that natural hazards pose. Now, if you want to take an analogy, conflict-related displacement, you might think about conflict as a driver of various kinds of displacement, fighting, for example, the targeting of other ethnic groups and so on. Those are all risks that emerge in conflict. Behind conflicts, there are factors which underpin the frequency and intensity of conflicts, factors like globalization, for example. Now, would we talk about climate refugees in the same breath as globalization refugees? Perhaps. They're similar levels of phenomenon, but they're very different from conflict or hazards as the immediate drivers of displacement, i.e. the immediate sources of risk. They are threat multipliers. The other thing, just to say as an aside, is that, of course, global climate change may well intensify hazards in certain parts of the world. At the same time, though, and I'm not in any way denying climate change here, let me be very clear, it will, in other parts of the world, make territories more habitable. Okay? So bear in mind that the effects of climate change are very highly differentiated. Now, of course, where it exacerbates the risk of natural hazards, those tend to be in countries which are by and large poorer, equatorial, and so on. The territories which are more likely to be opened up, if you like, tend to be in northern and southern climes. So again, those countries which already face serious risks of natural hazards are likely to face greater risks. Okay, below all of that, of course, is the point that we're really getting to, which is, well, risk to people. And it's important to realize that when we're talking about natural hazards posing risks to people, that those risks are filtered through societal structures. So a natural hazard, a storm that occurs at sea and doesn't affect anybody, do we worry about that? We don't. What we worry about is the storm that affects a coastal strip. And in that coastal strip, some societies are going to be more exposed to the natural hazard than others. And some people in society will be more exposed than others. We think about this as vulnerability. That's the concept that we use to describe this differential sort of risk. Think, for example, about earthquakes. A 7.0 magnitude earthquake in Haiti in 2010 killed 200,000 people. An earthquake 500 times stronger the same year in Chile killed 50 people. Why the difference? Well, because the societies were differently vulnerable to that particular hazard. There was more capacity in Chile to resist the effects of the earthquake. Okay? So human society and how it's structured is really important when we're thinking about the impacts of natural hazards, potential to cause disasters, and of course, those that may be driven by climate change. Now, as a second framing point, I'd like to say something that may seem counterintuitive, coming from somebody who's the director of the Refugee Law Initiative. But believe it or not, refugee law is not the global panacea to every problem. Okay? This is a really serious point. Most of the risks that are posed by natural hazards are not going to be risks that are primarily dealt with by refugee law. Okay? They're going to be dealt with by disaster risk reduction strategies. They're going to be dealt with within the context of climate adaptation and loss and damage strategies. They're going to take the form of migration over longer periods of time, as opposed to the sudden flight from a country from one day to another because of an immediate risk to life. So if we're interested in disaster risk, either risk posed by natural hazards, we're interested in the risks posed more broadly over longer periods of time by climate change. Those are the principal fields and strategies by which those risks are going to be met. Okay, so now let's get to the point of international protection. Well, most people who are going to be crossing borders in the context of these kinds of risks, the evidence shows, are people who will use migration pathways. Many of them will go to countries where they have family or where they have opportunities to study or where they have work opportunities. And I think one of the key takeaways of all of that is one of the most important things countries can do to address the risks posed by disasters and the background issue of climate change is to keep open mobility routes. Almost the worst thing that can happen is a disaster happens in El Salvador and all of a sudden the US closes migration routes for Salvadorians. Because by and large, that's where people who are most affected by those issues are going to be traveling through ordinary migration routes. As I'll come on to a little bit later, most countries, at least in the Americas, which is the region where I've done the majority of my research, already have exceptional migration categories that can be used for people who may not have a link of family, study, work, etc., but who are seriously affected by a disaster and shouldn't be returned there. Most countries already have national law on that issue, at least in the Americas region. Some have had it for up to 70 years. Okay, so these aren't new issues that we're dealing with in terms of cross-border legal response. I'm very happy to say a bit more about that later. Coming to the real point of the presentation then, international protection is going to be relevant to a tiny fraction of people. Most people are going to move within countries, the vast, vast majority. Those people who move outside countries are going to move through migratory routes of one kind or another. And a very, very small proportion are likely to apply for international protection or to merit it. Nonetheless, these claims already exist and they are worth considering very seriously. So I think that there are several points that would be worth making in relation to international protection conceptually. So the first thing to say is, of course, what's international protection really concerned with? It's concerned with the risk of harm in some way or another. And we drafted at the RLI a declaration last year, which was launched in June, and a background paper which talks through the ways in which one can conceptualize the kinds of risks that arise in the context of disasters and background issue of climate change. Some of the authors are here. But I would say that one of the key points is that if you're thinking about risk in the disaster context, there are a range of fairly complex scenarios in which risks can arise. And we identified some of these risks as follows. And what you'll see if you read down that list is that, yes, the manifestation of natural disasters, of natural hazards, or the disaster conditions flowing from the natural hazard can present a risk of harm to people that may be relevant to international protection. But many of the other sorts of risks of harm that arise in disaster contexts look much more familiar to us as refugee lawyers. They're disputes or controversies about environmental issues that might place people at risk of harm from people who don't want them talking about those sorts of things. There might be a breakdown of law and order that renders certain already marginalized or vulnerable people even more vulnerable. It may be that as a strategy of conflict, for example, armed actors intentionally degrade the environment in ways that triggers disasters. And of course, the nature of the response by the authorities to a disaster or the way that they're managing disaster risk might also exacerbate the risk of harm for inhabitants. So there's a whole set of risks here that can arise in the context of disaster. And we need to think about those broadly and not just focus on this thing, hey, there's a storm, hey, there's an earthquake. Yeah, there's a whole range of other sets of risks that we need to bear in mind. The other thing to say about all of that is that these disaster-related risks frequently are going to overlap with risks from other sources. As I've just mentioned, it may be that it's in the context of conflict. And in fact, all of the countries in the world today which are currently experiencing conflicts are also highly exposed to natural hazards of various kinds. So there's likely to be an overlap of risks or exacerbated risks. And as I mentioned earlier, there's the background issue of climate change over the longer term as well. So conceptually, we're dealing with situations that are quite complex factually. But does that mean that they're also legally complex? And this is the question that I'd like to come on to. So thinking about this, in collaboration with other colleagues who've been working on these issues, we think that there are at least two main overarching principles when you're dealing with international protection claims that take place against the backdrop of disasters. The first of those is that the fact that there's a disaster happening doesn't mean that automatically the person is eligible for international protection. But equally, it doesn't automatically mean that they're not eligible for protection. Each case has to be looked at very carefully on its facts to think about what the risks are, how those risks have emerged, and again, think about that in legal context. So many of you will have read judgments from Ward onwards, which say natural disasters are not something that produces refugees. They're not listed in the refugee definition, but the kinds of risks that we've just seen can emerge in disaster contexts may very well make people eligible for international protection. So you have to look at the facts rather than making assumptions about the disaster. The second thing is that we're all used to applying the rules of refugee law and human rights law to determine international protection. There aren't any other new rules that suddenly need to be applied in this context. We don't need to start reaching for rules around what constitutes a disaster under disaster relief law. We don't need to reach for climate change law to understand what is climate change, what is adaptation, and so on. We can simply go ahead and apply the rules as they already exist in refugee law and human rights law to this rather complex set of facts. So if we're thinking through how the Refugee Convention applies to these sorts of claims, then one key point is that we don't need to be thinking about using terms like climate refugees. They don't really get us any further. They might be a useful political tool, they might be kind of interesting, descriptive, they might be attractive and appealing, but legally they don't help us to determine any kind of protection issue. So we just continue to apply the standard Article 1A2 refugee definition to the facts. So how might that apply to the different elements in Article 1A2? Well, if we start with the element of being persecuted, it's evident that the intentional infliction of harm in those first four scenarios that I showed could easily qualify as persecution, as long as the harm is serious enough. By contrast, though, that fifth scenario, where it's a natural hazard that's producing the risk, it's difficult to say that a natural hazard is in itself persecutory. Nonetheless, it's important to bear in mind that the fact that a person's exposed to a natural hazard, that they're vulnerable to it, might well be due to social factors, particularly discriminatory practices by the state or society. And in those cases, that situation of harm might potentially be characterized as persecutory if the harm is serious enough. In other words, it's really the discrimination pushing people, let's say, into living in an area that's exposed to disasters, and that risk of harm is serious enough to be persecution. You need some kind of social tie there in order for these things to qualify as persecution. Moreover, in the disaster context, as in any other, the severity threshold for persecution should always be assessed cumulatively. For example, the serious everyday forms of discriminatory ill treatment faced by a member of a marginalized community or minority group must be considered cumulatively, along with their exposure or vulnerability to the effects of natural hazards, which are also due to that discrimination. In other words, we don't look at the issue of the risk posed by a natural hazard separately to the risk that is posed of lack of access to education or lack of access to jobs or being attacked in the street. All of those things must be assessed together to look cumulatively to see whether that risk is serious enough to amount to persecution. Now, if we turn to the reasons for persecution, then in disaster settings, it's evident that the human element of all of those scenarios will often be for reasons recognized by the Refugee Convention. For example, holding back disaster relief from political opponents or from despised ethnic minorities is very likely to engage established convention grounds. Equally, a government's disaster response and climate change policy are highly likely to be political issues relating directly to the functioning of that state. And as such, activism or criticism around these issues might very well engage grounds like political opinion, or at least be perceived by the persecutors as such in those terms. There's a rather more complex issue about how to evaluate well-founded fear in cases where the purported harm lies further into the future. This issue, for example, is raised by those scenario 5 cases where the feared disasters are slow onset. Could be talking about desertification or the rising of sea levels, for instance. Some courts have suggested that these kinds of slow onset harms can show a well-founded fear only where they are, quotes, imminent. But we take the view that there's no legal requirement in the Refugee Convention that a risk must be temporarily imminent in order for it to be well-founded. Rather, what we suggest is that time operates as a sliding scale as to the strength of evidence required to show that a fear is well-founded. So the further into the future that the feared scenario lies, the more compelling the evidence will need to be of the reasonable likelihood of its occurrence and the absence of potential mitigating factors. Moreover, given that many natural hazards, at least climate-related ones, are recurrent, seasonal, or worsening in the context of climate change, decision makers should be hesitant to find that a fear of such a hazard recurring is not in fact well-founded. In relation to protection, equally, that needs to be assessed in relation to the particular kinds of harms that we're talking about. So you'll be assessing protection not just in relation to police and judiciary, but also thinking about disaster risk management and so on, where that is in fact one of the risks arising. And of course, the risk of a disaster is always relevant to the issue of internal relocation, regardless of whether the persecution is tied to disasters or not. So I'd like to end by briefly addressing some of the other frameworks for international protection. It's, I think, well established that complementary international protection can take place under the non-reformant provisions of human rights law, including those codified by subsidiary protection provisions in the EU Qualification Directive. Now, crucially, most of the harms underpinning these non-reformant rules can be violated not only by harms emanating from human sources, but also those from natural sources too. And in this regard, we make it clear that the interpretative approach to such questions as the severity of the harm, the real risk of occurrence, nature of protection, etc., are likely to be highly similar to those criteria that we've just been talking about a moment ago in relation to the Refugee Convention. But there are certain complexities here dealing with non-reformant under human rights law. For example, the European Court of Human Rights jurisprudence has held that where the predominant cause of the harm is poverty or, quotes, the state's lack of resources to deal with a naturally occurring phenomenon, then a higher severity threshold of, quotes, very exceptional circumstances applies, in contrast to where the harm results from the direct or indirect actions of human actors, be they state or non-state. So in other words, the European Court is saying that for cases where the harm is, if you like, the scenario 5 type of harm, that won't engage Article 3 severity unless you can show that it is where the predominant cause is naturally occurring, i.e. a natural hazard, you need to show exceptionality. As yet, though, the court hasn't applied this higher threshold to any case involving reform to a country where disasters play into conditions of risk on the ground, as compared with its frequent application of this higher threshold to a whole line of cases involving challenges to removal on medical grounds. This may recognise the distinct nature of disaster contexts in which the risks of harm are so often shaped by human elements, whether they're caused by them, whether it's vulnerability and exposure to harm, they all have a strong human capacity. I think Ronan's also going to talk a little bit about this. Moreover, it's worth saying that human rights treaty bodies in other regions outside Europe and within the UN don't seem to have followed this European approach of exceptionality. But if it were applied to disaster cases ultimately by the European Court, it would raise some serious questions about what very exceptional circumstances would look like in the disaster context. And in the background paper we've written, you can get some examples of what that might be. Given that most of you, I suspect, don't deal with the regional refugee definitions in Africa and Latin America, I'll leave that for questions if anyone's particularly interested. But I hope that this talk's given a good overview of what we think are the key principles and norms that apply in this area. The real challenge is that the factual context of disasters and climate change is one of particular complexity. But the good news is that the essential legal rules governing international protection are essentially unchanged. All that's needed is clarity on how they apply to these new factual contexts. I hope this has given a sense of how we at the RLI think these particular interpretations play out. Thank you so much for your attention. I look forward to the question.
Our next speaker is Ronan Toal, who is a barrister here at Garden Court. He has been ranked as band 1 in the legal directories for a number of years and has been described as a fearsome intellect and the go-to person for complex matters. He's one of the long-standing editors of MacDonald's Immigration Law and Practice, one of the key practitioner texts, and has been involved in some of the key cases that us practitioners will be or have knowledge of. He will talk about introducing climate change into protection and human rights claims. Thank you, Ronan.
Thank you very much, Ubah. In thinking about this subject, I looked at the Daily website to investigate what the upper tribunal had to say about climate change. And I did a Control F search for the word climate change in the upper tribunal's jurisprudence. And to my surprise, it occurred only 3 times. I've got the cases which it occurred in those 3 cases. So there was AMM, which was a country guidance case about Somalia. There was AS, Afghanistan, a country guidance case about internal relocation to Kabul. And then there was OA, Somalia, which was the most recent country guidance case about Somalia. And climate change was mentioned only as a background fact. In fact, it was mentioned because they were quoting from reports, country reports that referred to climate change. And there was no analysis in any of those 3 cases as to any legal significance that the fact of climate change might have. And to be fair, in none of those 3 cases was the tribunal asked to engage in any such analysis. But I do think that the fact, maybe distinguishing what I'm saying from what David has just said, I do think that the fact that climate change lies behind some of the causes of people leaving their countries does have a particular legal significance. And what I suggest is that the adverse effects of climate change are caused by the acts and omissions of states and non-state human actors. And therefore, even if the immediate cause of harm, such as persistent failure of rains giving rise to drought or inundation by rising sea levels, even if the immediate cause of harm is the behaviour of the natural environment, it is nevertheless contributed to by human, state and non-state actors. And consequently, those harms can and should be addressed within a conventional human rights and refugee convention framework, recognising that they are caused by human actors. So I'm going to start by looking at Article 3 and starting, in fact, close to where David finished, which is the approach in the Article 3 jurisprudence to situations of dire humanitarian distress and dreadful living conditions that the European Court of Human Rights has addressed a number of times and the domestic jurisprudence has also addressed. And the starting point there is that Article 3, or no right under the European Convention on Human Rights, guarantees a person a right to a home or a particular standard of living or conditions of living. And yet there have been occasions when the courts have accepted that dreadful living conditions or dire humanitarian circumstances will give rise to a breach of Article 3. But the the jurisprudence on that issue has gone in roughly speaking, well, in two directions. I mean, in fact, Lord Justice Laws in a case called GS India, which was about sending people suffering from end-stage renal failure back to their countries and quick death thereafter, whether that would breach Article 3. He talked about a fork in the road in the Article 3 jurisprudence, and the fork in the road was identified in the case of Sufi and Elmi against the United Kingdom, which was a case again about Somalia and whether the generalized violence and drought and famine in Somalia, having to return to those conditions, whether that could be prohibited by Article 3. What the court there said was that if the humanitarian conditions were solely or even predominantly attributable to poverty or to the state's lack of resources to deal with a naturally occurring phenomenon such as drought, then the test in N and the United Kingdom would be applicable. Now, the test in N and the United Kingdom, as I'm sure we know, imposed a very high threshold. It was the very high threshold set in D against the United Kingdom. And in fact, it's such a high threshold that I think D was the only person who managed to cross that threshold. And that was because he was due to be sent back to St. Kitts. He was dying of AIDS and his death was expected in a week or 2 weeks' time. And in St. Kitts, there would be nobody to look after him as he died, not even a bed for him to die in. That was said to breach Article 3. But N against the United Kingdom, it was again somebody suffering from AIDS. Death was not quite as imminent, but removal would result in fairly speedy death in very dreadful circumstances. But the court there said that he did not meet the high threshold. The high threshold requires very exceptional cases where the humanitarian conditions are equally compelling to those in D. And it was said that N did not reach that standard. And it said that the reason for needing such an exceptionally high standard was the alleged future harm in N's case. The alleged future harm would emanate not from the intentional acts or omissions of public authorities or non-state bodies, but instead from a naturally occurring illness and the lack of sufficient resources to deal with it in the receiving country. And now that test, I mean, we know that test has been slightly ameliorated by the more recent decision of Papashvili against Belgium, which was approved in the United Kingdom in the Supreme Court by AM Zimbabwe. So in the light of Papashvili, it's now sufficient to show, it's not necessary to show an imminent risk of dying, but a person would face a real risk on account of the absence of appropriate treatment in the receiving country, or the lack of access to such treatment, of being exposed to a serious, rapid and irreversible decline in his or her state of health, resulting in intense suffering or to a significant reduction in life expectancy. So that's the lower but still very high threshold to make good an Article 3 case, where the issue is health. Now, the upper tribunal in the UK in a case called Ante, a very long title, but a case called Ante, again, it was about removal to Somalia. The tribunal there said that the Papashvili test applies not just to cases where the issue is returning somebody who's got a dreadful illness to a country where they won't receive treatment, but it generally addresses humanitarian crisis, dreadful living conditions. And in theory, in such a case, applying the Papashvili test, one could resist removal to dire humanitarian conditions on Article 3 grounds. So coming back then to Sufi and Elmi and the fork in the road that Lord Justice Laws talked about. The Strasbourg court there, looking at the situation in Somalia, the situation of pervasive violence, drought and famine, said that it is clear that while drought has contributed to the humanitarian crisis, that crisis is predominantly due to the direct and indirect actions of the parties to the conflict. Therefore, the approach in N is not appropriate, and the court rather prefers the approach in MSS against Belgium. MSS against Belgium was a case about destitute refugees living in Greece, living on the streets, with no support from the state, no accommodation, no means to attend even to their basic personal hygiene, and also the hopelessness of no prospect of their situation improving. So the court in MSS said that the mental and psychological want that those people experienced was such as to breach Article 3, and it didn't go into having to say you meet the applying the high threshold. The reason it didn't apply the high threshold was that the predicament of the people in Greece was caused by the actions of the Greek government, or rather the omissions of the Greek government, the failure by the Greek government to apply the reception directive, which required it to look after asylum seekers and refugees. So it was because it was the acts and omissions of the Greek government that was responsible for the plight of those people that it was found in MSS Belgium that it would breach Article 3 to send the asylum seeker back to Greece. I just want to go back to the Somalia country guidance case, AMM. I mean, it was argued in that case that the tribunal should follow the Sufi and Elmi approach, and that the tribunal should find that the dreadful circumstances in Somalia were predominantly caused by the parties to the conflict in Somalia, and therefore it should not have to apply the exceptionally high threshold in order to find a breach of Article 3 from sending people back to Somalia. And the tribunal was not persuaded by that argument. It nevertheless found that it would be a breach of Article 3 to send people back to Somalia because it found that, in fact, the N threshold was met in the case of Somalia. It found that the cause of the problems faced by Somalis was predominantly the drought. It was not predominantly the actions of the parties to the conflict. And it highlighted that the situation in Somalia was unique to our planet at the present time. And it was a situation of sufficient exceptionality to cross the threshold set in N. So that shows you how difficult it is to resist removal on Article 3 grounds when the fear arises from what is said to be a naturally occurring drought. I've mentioned in that list of cases the case of Pretty in the United Kingdom, which is a good statement of the Article 3 test in the non-exceptional cases scenario. It talks about the types of treatment which fall within the scope of Article 3 of the Convention. The court's case law refers to ill treatment that attains a minimum level of severity and involves actual bodily injury or intense physical or mental suffering. When treatment humiliates or debases an individual, showing a lack of respect for or diminishing his or her human dignity, or arouses feelings of fear, anguish, or inferiority capable of breaking an individual's moral and physical resistance, may be characterised as degrading and also fall within the prohibition of Article 3. And then Lord Bingham, in the case of Limbuella, nicely summarised that or crystallised that by saying that, having referred to that passage from Pretty, he said, that description is in close accord with the meaning one would naturally ascribe to the expression. Treatment is inhuman or degrading if, to a seriously detrimental extent, it denies the most basic needs of any human being. So that quite nicely captures Article 3 harm of the non-N, non-Papashvili kind. Well, what I indicated I would suggest is that the adverse effects of climate change are caused by the acts and omissions of state and non-state actors. And therefore, if a person is fleeing the adverse effects of climate change, the approach in MSS and Pretty, and not the approach in N and Papashvili, should apply. So, make good the point that the effects of climate change are caused by the acts and omissions of human actors. The starting point, I would say, is the definition of climate change in Article 1 of the UN Framework Convention on Climate Change, which says a change of climate defines climate change as a change of climate which is attributed directly or indirectly to human activity that alters the composition of the global atmosphere and which is in addition to natural climate variability observed over comparable time periods. And then in the same article, which is the definitions provision in the convention, it says that adverse effects of climate change means changes in the physical environment or biota resulting from climate change which have significant deleterious effects on the composition, resilience or productivity of natural and managed ecosystems, or on the operation of socio-economic systems, or on human health and welfare. So that's the foundational international instrument on climate change, which is defining the effects of climate change as being caused by human activity, human inactivity. Then to move into a slightly more empirical position, I'd refer to the Intergovernmental Panel on Climate Change, cited it there, the Climate Change 2023 Synthesis Report Summary for Policymakers. And it's a document which is produced by the IPCC on the basis of the consensus reached by the parties to that panel. And it's a document which is produced by, I mean, every single word, every single phrase, every single sentence in the document is subjected to the most intense, anxious scrutiny and agreed by the parties to that panel. The report I mentioned says in its description of itself that it summarizes the state of knowledge of climate change, its widespread impacts and risks, and climate change mitigation and adaptation. And interestingly, and I would say very significantly, in the case which is going on in the International Court of Justice at the moment about states' obligations in respect of climate change and in respect of breaching any of those obligations, the United Kingdom government is one of the governments that has made a statement to the court. And in its statement, filed on the 18th of March last year, it says that, with reference to that document I just mentioned, that its conclusions are, quote, clear and incontrovertible, end quote. So at least as far as one is relying on what the IPCC in these reports says, in support of a human rights or asylum claim, the government's not really going to dispute the facts arising from that document, or those documents. And that report makes very, very clear that the international scientific consensus is that climate change is caused by human activity, and in particular the emissions of greenhouse gases. It says, for example, that widespread and rapid changes in the atmosphere, ocean, cryosphere, and biosphere have occurred. Human-caused climate change is already affecting many weather and climate extremes in every region across the globe. This has led to widespread adverse impacts and related losses and damages to nature and people. Vulnerable communities who have historically contributed the least are disproportionately affected. So that is, as the UK government says, clear and incontrovertible. So the same report lists, or rather one can identify in the report, various of the adverse effects of climate change. They include damage and increasingly irreversible losses in terrestrial, freshwater, cryospheric, and coastal and open ocean ecosystems. Reduced food security and affected water security, increases in extreme heat events. The occurrence of climate-related disease has increased, mental health challenges associated with increasing temperatures, trauma from extreme events, loss of livelihoods and culture, climate and weather extremes increasingly driving displacement, and economic damage from climate change. Individual livelihoods have been affected, e.g. through destruction of homes and infrastructure, loss of property and income, human health and food security with adverse effects on gender and social equity. In all of those effects, one can quite see that if the effect was sufficiently serious on any particular individual, an individual will be able to say these are effects of human activity. They are the effects of state and non-state actors, their acts and their omissions, and they are sufficiently grave in their impact or my feared impact to amount to a breach of Article 3. So I would say that the direct effect, or those effects of climate change, are the kinds of harm to which the MSS Sufi and Elmi line of cases apply in the Article 3 context. I would say too that the fact that the human activity causing those harms is likely to have been done in a country outside the place where the harm is feared. So, for example, the Somali pastoralists who have to watch the fact it's greenhouse gas emissions from the rest of the world, not from Somalia, that is causing, makes no difference. There's nothing in the text, purpose or context of the ECHR or the Refugee Convention that says that the cause of the harm causing the violation of the right has to emanate within one's own jurisdiction. And in fact, the Grand Chamber of the European Court of Human Rights in the recent case of Duarte Agostinho against Portugal acknowledged a couple of very important things. Firstly, they acknowledged that states have ultimate control over public and private activities based on their territories that produce GHG emissions, greenhouse gas emissions. So states are responsible for what polluting factories, polluting transport systems, polluting agriculture does. And secondly, there is a certain causal relationship between public and private activities based on the state's territories that produce greenhouse gas emissions and the adverse impact on the rights and well-being of people residing outside its borders. So clear acknowledgement there, I would say, that what is done in one state can breach the human rights of people living in another state. So if an individual is able to show a real risk of being the victim of one or more of those adverse effects with sufficiently serious consequences and can show that their own state cannot provide adequate protection from them, then removal from the UK back to that state may well breach Article 3. And I'll come on in a moment to deal with what the state has to do by way of, well, I'm sorry to be running out of time. I mean, I'm going to put my hat on at this stage. The reason for that is that I'm going to talk about the decision of the Grand Chamber in, and I'm sorry, I can't really pronounce the name well, but it's Verein Klimasignorinen Schweiz and others against Switzerland, which was heard about the same time as the Duarte Agostinho case. The reason I'm putting my hat on is because Mark Willers, who was the head of chambers here, was one of the lawyers involved in the case. And I want to be able to take my hat off to him and all the other people. That court is a groundbreaking case. And what the Grand Chamber decided there is that the scope of protection under Article 8 of the Convention extends to adverse effects on human health, well-being and quality of life arising from various sources of environmental harm and risk of harm. Similarly, the court derives from Article 8 a right for individuals to enjoy effective protection by the state authorities from serious adverse effects on their life, health, well-being and quality of life arising from the harmful effects and risks caused by climate change, which I think is really quite extraordinary. I mean, that's, and so extraordinary actually that the UK's judge was unwilling to agree with it and wrote a decision as to why that was all wrong, but all the other judges agreed with them. And I'm not going to go on to talk further about what the court there said about Article 8 and the way it can be breached by the effects of climate change, because I want to leap on to cases about private life and family life in the United Kingdom, as I'm running out of time. So we know that Article 8 may be breached by the removal of a person from the UK if the removal results in a disproportionate interference with their right to respect for private or family life. And that has been codified in the immigration rules to say that, generally speaking, an individual would be entitled to stay in the United Kingdom if there would be very significant obstacles to the applicant's integration into the country where they would have to live if required to leave the United Kingdom. And if one's not talking about that immigration rule, then one is just talking about Article 8 as the jurisprudence has developed it. The question there is, the ultimate question is, would expulsion of that individual result in a disproportionate interference with their protected right? In other words, would expulsion strike a fair balance between the individual's interests and the interests of the UK? Or would the individual's interests outweigh the interests of the United Kingdom? And what I want to talk about is the relevance of the effects of climate change in the country to which the individual may be removed, through the attribution of weight to the public interest in the individual's expulsion. Now, generally speaking, states have an untrammeled right to control who may enter, stay in, or be expelled from their country. And that right is trammelled only by obligations such as those arising under the Refugee Convention or other human rights conventions. But otherwise, it is an untrammeled right that the state has. However, when one is interpreting and applying Article 8.2 of the Convention, that's the provision which allows the state to interfere with the protected right. Article 8.2 has to be interpreted in the light of any rules, relevant rules and principles of international law applicable in relations between the contracting parties. And the Convention should, so far as possible, be interpreted in harmony with other rules of international law of which it forms part. And that comes from the case of Rantsev, where the court relied on that principle in order to interpret Article 4 of the Convention, which is about human trafficking, in accordance with the Council of Europe Convention Against Trafficking. It used that to construe Article 4. The Supreme Court in the United Kingdom has applied the same principle in the Article 8.2 context in the case of ZH Tanzania, where it took the principle in the UN Convention on the Rights of the Child that the best interests of the child is to be a primary consideration, and used that to interpret the scope of Article 8.2 in a case involving children. So I would say that there are a number of principles, legal principles, that are relevant to and should drive the interpretation and application of Article 8.2. The first of those is the principle that the European Convention on Human Rights is a guarantor of the rule of law in Europe. And I get that phrase from the Duarte Agostinho against Portugal case, which in turn cites a load of other cases for that principle. The second principle that Article 8.2 has to be applied in the light of is the principle of equity, which is an international law principle. It was described in a case with a terribly long name concerning the continental shelf, Tunisia against Libya. It's a legal concept of equity as a general principle directly applicable as law. Moreover, when applying positive international law, a court may choose among several possible interpretations of the law, the one which appears in the light of the circumstances of the case to be closest to the requirements of justice. And going back to the IPCC summary report, remembering that those most vulnerable to the effects of climate change are the ones who have had least responsibility for causing those effects. Well, the principle of equity should bite when one is looking at expulsion of such a person. The third relevant principle is expressed in the preamble to the UN Framework Convention on Climate Change, which said that states have the responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. And that's a principle which there's a long, very well-established jurisprudence behind that principle, one case being the legality of the threat or use of nuclear weapons, which says that the existence of the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control is now part of the corpus of international law relating to the environment. The fourth principle, which is relevant here, is that states are obliged to make reparation for injury caused by internationally wrongful acts for which they are responsible. And I'm quoting there from the Law Commission's draft articles on responsibility of states for internationally wrongful acts, which are, in spite of the word draft, apparently authoritative descriptions of states' obligations in that context. And one of the obligations of the state when it commits an internationally wrongful act is to make full reparation for any injury that is caused by that act. The fifth principle that is relevant in this context are a couple of commitments made by the United Kingdom under the UN Framework Convention on Climate Change, Article 4. The first of them is to formulate, implement, publish, and regularly update national programs containing measures to facilitate adequate adaptation to climate change. And another obligation is to take climate change considerations into account to the extent feasible in their relevant social, economic, and environmental policies and actions. Now, I would say that those principles should inform any decision that the UK government has to make as to whether it would be proportionate or disproportionate to expel a person to a country where they may face the effects of climate change. Firstly, the UK has substantial responsibility for climate change. It's not alone responsible, but it has substantial responsibility. Secondly, it has known about the adverse effects of activities that it conducts or permits in the UK, at least since 1992, when that convention was drawn up, but much earlier than that. Consequently, I would say the UK has an obligation to make reparations for injury caused by its wrongful acts, including injury suffered by the migrant trying to stay here in their own country, or injury that they apprehend should have if they go back there. The rule of law in Europe requires regard to be had to those various principles. So too, I would say, do the obligations that the UK has taken up under the Framework Convention. And then lastly, repeating or going back again to the Duarte Agostino case, it quite nicely said that climate change is a global phenomenon and each state bears its share of responsibility for the global challenges generated by climate change and has a role to play in finding appropriate solutions. Well, I would say that there are many migrants who are present in the UK, their presence being an instantiation of that global challenge. And the finding of an appropriate solution must be informed by those various considerations I've been mentioning. So I will stop there.
Thank you very much, Ronan. Our next speaker is Yumna Kamel. She is the co-founder and executive director of Refuge, a legal think tank which is dedicated to climate change migration and a joint initiator of the Climate Law database of cases, an officer at the migrant justice charity Right to Remain. And she's going to speak to us about the database and how it can be used in any cases you may be running.
Evening, everyone. Hi. I'm just going to set a timer. So I'm tasked with a rather fun task actually this evening of just not going into anything of substance and just introducing Earth Refuge and our database, which hopefully will take the edge off what you've been learning this evening and can be used as a practical tool as you embark on your journeys into climate displacement and hopefully building precedents. So the Climate Law database is a project of Earth Refuge in collaboration with the Global Strategic Litigation Council for Refugee Rights, which I will be calling the Council because I only have 15 minutes. And it's also, we're also partnered with the Raoul Wallenberg Institute of Human Rights. And we've received massive support from the pro bono teams at DLA Piper and Evershed Sutherland. Very grateful to them. We couldn't have done it without them. I thought I would give you a brief overview of what led to the launch, the creation and the launch of the database. We've heard that climate displacement is a global priority, a global crisis. it's really important to note that it's something that's already happening. It's not a future issue. It's something that's already happening and it's going to get worse. By contrast to what Ronan said about the upper tribunal in the UK only mentioning climate change rather 3 times, climate migration has been mentioned in our own parliamentary politics about 300 times in the last 3 years. More often than not in tandem with pejorative language about swarms of people, mass movements, particularly of people from the so-called global south to the global north. I'd like to confirm that that's a myth. The majority of climate-driven displacement or movement is internal, so not much cross-border movement happening in contrast. However, disasters did trigger 3 times more displacement than conflict and violence in 2020, according to the Internal Displacement Monitoring Centre at the Norwegian Refugee Council. And with this lens in mind, I'd like to introduce the work of Earth Refuge. So my co-founder Stephanie Hayder and I launched Earth Refuge in 2020, coincidentally, when it came to our attention that climate displacement was such a huge issue, and yet there wasn't a coherent body of rights. And there wasn't sort of a space for legal learnings, and there were no cases that we could find. That changed, but then we couldn't find any. So we launched this think tank, this legal think tank, with 2 key points in mind. Community-focused engagement, so actively engaging with communities impacted by climate displacement, asking them what they were experiencing, what they wanted, what they needed, and whether moving was even an option or a want. Many communities who are facing climate displacement don't actually want to move, or because of various factors, including, well, primarily socioeconomic factors, moving isn't an option. So we sought to engage with these communities and then try to match those needs outlined with legal solutions, which is ambitious, but it does work. We're not into empire building. We kind of consider ourselves a boutique organization because of that link to communities. So we work small, but impactfully. So we pursue those legal solutions in 3 key ways. Our 3 pillars are legal education, advocacy, and research. The education is mainly through working with law school clinics around the world, working with students to effectively plant the seed of climate displacement before lawyers enter the profession, so that it's on their radars. Under the umbrella of Earth Refuge, the International School on Climate Migration was also launched 3 years ago. I'm happy to say that some of the students, the alumni, are in the room, and Emily was also one of them. So it's a summer school that runs each summer for 6 weeks, engaging with a different topic that's interconnected with climate displacement each week. So experts in those fields are invited to come speak to the cohorts, and someone with lived experience is always present as well. And at the end of the program, students have the option to apply for a capstone project where they get to engage the learnings they've gleaned practically. And so over the summer, a number of students from the capstone actually worked with us on the database. I think that advocacy and research is self-explanatory. We kind of advocate for the cause, particularly in legal spaces, to encourage practitioners to engage with climate displacement, whether they're coming from the climate or environmental angle or the immigration angle, and sort of to reiterate what David and Ronan said so gracefully, which is that it doesn't take masses of new learning. It's a shift in perspective to engage with this issue. And then the research is sort of complementary. We do key research into active cases, typically immigration cases, but we've also done legal briefs for climate cases as well that engage with the movement of groups. Key trends, well, I think this has already been mentioned, but most movement is internal, and most movement is also faced by communities that are already marginalized, so racially, socioeconomically, so on and so forth. So with all of this in mind, the spiel in mind, we decided to put our heads together with our colleagues and create and launch this database. And the idea behind it is to provide a free public library of global litigation that engages with climate displacement in order to create an easily accessible tool for practitioners, but also to use that tool as a springboard for future strategies for tackling this issue, but also to increase precedence in courts around the world. So the database engages sort of two elements. We have case summaries and we have spotlight blogs. The case summaries are for now sort of narrow in scope. We only take on immigration or any sort of movement cases, that includes internal displacement as well, that feature climate or environmental factors, either in the arguments of the parties or in the judicial decision itself. And also we have this sort of subsidiary group of cases where climate and environmental factors were mentioned in the obiter dictum as well. The cases are analyzed according to a uniform form. So a brief summary, engagement with the arguments, and then the key sort of thing that sets the database apart from other resources is we do a deep dive into the lessons learned from the perspective of climate displacement. So what arguments worked, what didn't work, how did the court engage with this? Was it positive, was it negative? And what lessons can be taken moving forward in building a body of climate displacement law? And then the spotlight blogs engage with cases that are pending. So cases that are similar in that they're movement cases, so internal displacement or cross-border movement, where a final decision has not yet been handed down. And often these blogs are written by the lawyers who are actively engaged in these cases. And it enables us to follow cases that are currently out there, but also so that we're able to map out trends. And we've already mapped out trends of the cases that have been uploaded in terms of who has been impacted, what government responses have been, and what the outcomes are, and indeed what the rewards have been, if any. Should you want to be involved or spread the word in your networks, we currently have a call out for proposals, not full submissions, but proposals for the spotlight blogs. Of 100 words max. So if you are involved in a case that falls within the remit of the database and you would like to have it featured, then please do get in touch. I've got plenty of links in the slides and I know they will be sent to you. Further ways of getting involved before I hopefully am able to share the rough version of the database with you of it. The beta version is live, so it's rough. It's a little bit rough around the edges. It's fully functional. But the idea was to upload it so that civil society would be able to engage with it and actually provide feedback so that we would be able to improve it before our final launch, which is next month, mid-February, she says. So we're ready for feedback, we're ready for new cases, and we have this call for pending cases. And I really hope that I'm able to share this screen and share. So the database is up. There's a number of cases up there already. I know that people are already using it actively. My next challenge is learning how to scroll. So we have a timeline of cases which is about to be bolstered because ahead of our launch, over 50 new cases are going to be added. So you can see the lifeline of a case rather, and then we have a number of filters running from host country to the type of mobility, so cross-border or internal or both. The decision and the judgment, so whether it was in favor of the applicant or in favor of the state, as most of the cases we've dealt with so far are private actors against state bodies, but we also have some cases that are against corporate bodies as well. And then the case type in terms of our categorization, so were the arguments engaged with by the parties, by the court, both, or is it in the obiter? And then the type of hazard, which is interesting, and this is an ever-growing list. So on and so forth. So I know should you want to provide feedback, the link is at the bottom of the page. I'm going to hopefully just show one example of a summary. I'll go with a rather obvious one. So apologies to anyone who is well-versed in the world of, I should say this has nothing to do with the database and entirely to do with my tech ineptness. So here is the summary for the case of Teitiotto, which is a landmark case. I should say we've kind of moved on from the ethos of that case, but it's a good starting point. So the summary will always highlight the key sort of flagging factors and then provide a description, parties, court, background, and the protection rights engaged. So whether it's a right to life, right to a healthy environment. And then the key part is the lessons at the bottom. And this is where the analysis has been carried out by our team of what key lessons can be pulled from the case for the sake of climate displacement, and how they can be utilized in future litigation. That was a whistle-stop tour of the database. I promise it's going to be prettier in a few weeks as well. Let's go back to my slides. So looking forward, I should say I'm here on behalf of Earth Refuge, but I'm also a member of the council. And so our collective goals are as follows: to grow sort of a body of law, but a body of learnings that can be accessed by anyone, particularly practitioners, but not narrowed to practitioners only. So we hope to grow the database with your input. We started running tailored trainings. I'm happy to say that David Cantor ran our first one, and it was a hit. But we've also been helping draft regional strategies on how to grow our collective learnings on climate displacement, because it manifests so differently in different communities. And then to drive litigation by proxy, to build on networks and again, coordinate litigation efforts, and to finally maximize success by providing direct legal and educational support. And just to highlight the support we've already carried out, the council contributed an amicus brief with Caribbean civil society in the recent Inter-American Court of Human Rights' advisory opinion on the climate emergency. So the brief is linked there. And in those proceedings, the court engaged heavily with the notion of climate mobility and immobility. The Latin American regional litigator for the council has also recently been taken on board of a massive Brazilian salt mining case, where the lives and homes of over 60,000 people were impacted by a salt mining disaster. And it's going to be heard in the Dutch courts. And finally, we also at Earth Refuge contributed an NGO brief to the ICJ's recent advisory opinion on the obligations of states regarding climate change. And that brief was relied upon by a number of state parties as well. I think we were the only organization that submitted a brief on climate displacement, solely on climate displacement. So those are our contributions. Other key links are obviously to provide feedback on the database. I do hope you're able to use it. Should you be interested in joining the council, you can also apply to do so. Or if you simply would like to request support, that's also an option. Already mentioned Spotlight proposals 3 times, so I won't again. And if you have other queries, you can always drop me a line. So thank you so much. And thank you to Garden Court also for hosting us. Thank you very much.
Thank you, Yumna. Right, our final speaker for the evening, definitely last but not least, is Emily Rowe. She's the chair of the Climate Emergency Working Group at the Refugee Legal Support, and she's a founder member of the Immigration Climate Collective. She was recently a delegate at COP29 in Azerbaijan, and she aims to share some reflections of the COP process and climate-related migration.
Yes, I'm going to talk about COP29 with a migration and human rights lens. Having been fortunate enough to have the opportunity to be a delegate at COP29 in Azerbaijan at the end of last year, I wanted to share my experience and learning from that. And this is for those of you who, like me, might have thought that COP focused solely on environmental issues and had no relevance for migration and human rights. So I have 10 minutes. It's going to be a bit of a whistle-stop tour, some pointers to further resources if you want to take it. So this is our outline. This is what we're going to cover. We're going to have a look at the COP climate conferences, the context to this one, the outcome, and any relevance to mobility and human rights issues. Have a bit of a look forward, especially picking up some interlinkages with the ICJ advisory opinion process. So this is about the COP process itself. The others have mentioned, so the UNFCCC was from 1992, signed by most countries in the world. It has a consensus-based structure where all parties need to agree. That was followed by the Kyoto Protocol in 1997. And this included the principle of common but differentiated responsibilities, binding developing countries and developed countries, and by placing a heavier burden on them under this principle, because it recognises that they're largely responsible for the current high levels of greenhouse gas emissions in the atmosphere. In 2015, the Paris Agreement had the main goal to cut global greenhouse gases in order to limit global temperature increases to well below 2 degrees above the industrial average, with a goal of holding it to 1.5. And here I've added, you see a preamble extract noting our human rights lens and how that's mentioned there. Moving on then to the context of COP29 this year, I want to draw out a few key background elements. So first of all, the worsening climate emergency. I think we all know about that, and that's probably why we. So we're in a situation of rising emissions with coal use, for example, at an all-time high. Climate itself, so this has been noticed last year as the hottest year on record, and over 1.5 degrees. Now, just with a caveat, that doesn't necessarily mean we're over the climate target yet, because that's a long-term phenomenon. We're in a difficult geopolitical situation. Take the key example, as we'll all be aware, and Donald Trump has called climate change a hoax, threatening to pull out the US from the Paris Agreement, which affects both the leadership of both the biggest emitter and also the funding available from the richest by GDP. That imminent change by the US was very present and really cast a shadow over the conference. As far as hosting by Azerbaijan was concerned, it's a state with a poor human rights record. For example, Human Rights Watch noted politically motivated bogus criminal charges to prosecute and imprison civic activists, journalists and human rights defenders just months before hosting COP29. It's also a petrostate. In fact, it was the very first country in the world to start industrial oil drilling back in 1840. And it's very evidently by far its main source of income. And you feel that very viscerally when you're there. There are oil rigs, for example, in the suburbs of Baku. The wealth is very obvious and the source that would replace it is not. You can see that it belongs to a set of countries that are going to find it particularly challenging to transition. So who participates in COP? A mix of parties, so people linked to the countries, and also observers such as NGOs. This time there were approximately 65,000 people registered to attend, and they're spread across two different zones. So the blue zone, which is managed by the UNFCCC, open to accredited delegates and hosting formal negotiations in the country pavilions. Notoriously, there were around 1,700 fossil fuel lobbyists and also Taliban administration officials invited as observers. Then there's the green zone managed by the COP29 presidency, open to non-accredited delegates, business and civil society. Who is there and who is absent are very apparent. For example, there's a clear imbalance in regional representation, far more. Here, the UNFCCC aimed to address that by giving more places, they call them badges, to global South countries to encourage more diverse voices. That was well-intentioned, but quite a good example of something that had less impact on the rising number of that group than you might imagine. That's unsurprisingly, as it didn't come with any funding attached, and it's a very expensive process. There are plenty of other invisible barriers to effective and meaningful participation as well. Indeed, the UN Special Rapporteur on Human Rights and Climate Change, Elisa Nogueira, has spoken about how COP is locked in an ineffective approach that's blind to the disproportionate harms of climate change, rooted in deep systemic inequalities, and with states acting in bad faith. So we can see why, given all that, the reform has been a big issue. And I've given you a couple in the resources there of other resources to explore. So scope for input for those with particular expertise, such as Indigenous peoples or those with lived experience, are critical. And for the refugee communities whose views were shared with Refugees International, it was emphasising that as one of the most impacted, it was vital for them to both be able to be facilitated to attend and be consulted. The Club of Rome is a platform of leaders proposing, for instance, multi-stakeholder actors and shifting from goals and ambitions to concrete actions. So the outcomes then. What was the deal in COP29 and how did it play out on the ground? Obviously, there were a lot of different things decided at COP. As it was decided, it was dubbed the Finance COP. That was the key aim of this one, to get a deal on the money. I'm just focusing on this particular headline aspect to give you in particular because it's the gateway and the enabler to the others. So that sounds like a lot of money, 100 billion. But I just want to put that in context. This US defense budget alone is more than 800 billion. Rich nations currently spend 378 billion yearly on fossil fuel subsidies. And the last figure I saw this morning for the LA wildfires is coming in at about 200 billion, just the LA wildfires, just part of one country. So also a critical point is how the money is delivered, which is mostly in the form of loans, adding to the debt burden. Harder to get and for higher rates for higher risk developing and particularly fragile states, the kind from whom we get refugees, only approximately a quarter in the form of grants. So on the right is a selection of commentary on the outcome. I think you can see why it was for that reason that it was the representatives of the least developed countries who called it a staggering betrayal of the world's most vulnerable. Not just to do with the money, but to do with the process. It included a decision being gavelled without letting countries such as India had requested to take the floor. And remember, these are meant to be decisions by consensus. And also Saudi Arabia had seemingly been allowed to alter a text. An insurance policy for humanity, that was Simon Steele, who is the executive secretary for the UNFCCC, perhaps more likely for his position to put a positive spin. Closing remarks of the EU commissioner, less than we liked. Significant perhaps one of the negotiating blocks. Because the Azerbaijani COP president said he was glad that he got a deal, but interestingly, noting who he blamed for the poor deal and saying that he thought China would have been prepared to contribute more if others had. So what does that have to do with? So, as I touched a little on the process of the UNFCCC. The first report of the IPCC migration would have been one of the main consequences of climate change was in 1990, what it's been called the human face of climate change. And into a COP text itself was in 2010. It's thought of as being traditionally sidelined, with more and more presence each year. So we can see that in these few examples I've given to give you a taste and how that's worked into the negotiating texts and into how the presence at COP itself. And you can see in terms of the texts how people have worked to put human mobility on the international agenda, particularly on advancing adaptation efforts, with voluntary migration being seen as an adaptation strategy and also relevant to addressing loss and damage. On the other hand, you can see that what it doesn't create is legal protections for those on the move to climate change. It's not a place for asylum or immigration policy. In terms of presence, then that advisory group on climate change and human mobility is an expert group with a wide-ranging membership, which offers technical support to the UNFCCC, collaborating and coordinating amongst them to ensure informed input into decision-making. There were 2 dedicated pavilions. So to give you an idea of scale, there are about 150 in the blue zone. So that's the IOM and the Global Centre for Climate Mobility. You can see the work of the IOM in their environmental portal. The Global Centre for Climate Mobility is a UN-funded partnership addressing climate-related movement with notably a number of regional initiatives. This year there was also a thematic day at the Capacity Building Hub, I think for the first time, so some evidence of momentum towards increasing visibility. And also there were certainly other sessions. I'm just giving this example. Azerbaijan as the host, feeling the impetus to run a session about climate. So moving on then to human rights related issues and having a look again in the same way at negotiating texts and some sessions which took place in those IOM. The Global Centre for Climate Mobility. See here in the negotiating texts how certain countries tried to push back against human rights friendly wording in some texts. And those other examples of sessions I've included, things we thought that I wanted to draw our attention to try and fill our gaps in our knowledge. I think, again, as been mentioned, that really the critical importance of those interlink between climate, conflict and displacement. And it was during COP that a key report from UNHCR was launched, No Escape, show how climate shocks are interacting with conflict, pushing vulnerable people to even more dire situations. The conflict remains the primary cause of cross-border displacement. The impacts of climate change, such as rising temperatures, on the availability of natural resources, such as fresh water and productive land, can aggravate tensions and weaken social cohesion, deepening existing inequalities and injustices, significant health effects, affecting the right to life, physical integrity, health, and adequate standard of living. In terms of climate and trafficking, climate change is known to raise the risk of trafficking, and Anti-Slavery International were prominent in pointing that out. And I just wanted to raise awareness of another resource of theirs, which is similar to Yumna's case law database. So this is a hub on modern slavery, the links between that and climate change, which is just filling up like the climate. In terms of working with vulnerable groups, Amnesty has started relatively recent engagement with working with climate change as an intensifier of human rights abuses. And in terms of children, the disproportionate impact on them is a classic case of those who have the least cause the crisis being the most affected. For example, by early marriage, forced work, and increased susceptibility to disease. Disaster displacement is something else that David mentioned, that sometimes we will need to be able to be au fait with, so to understand what constitutes disaster, the different elements, constitutes risk, to understand how it can be reduced, and the related displacement. I'm just drawing your attention to some resources by the platform for disaster displacement. And finally then, I wanted to look forward the ICJ advisory opinion process, how that might impact on the process. In fact, we can say that if COP worked as a successful and all-encompassing process, there wouldn't have been a need for the advisory opinion process. This year's inadequate deal illustrates exactly why judicial scrutiny and legal clarity is needed and needed urgently. Whether existing international frameworks such as the UNFCCC and the Paris Agreement and others impose enforceable obligations on states to mitigate climate impact. This is important because while existing treaties such as the Paris Agreement outline goals and targets, and lack enforceable provisions or mechanisms, historical responsibility, disproportionate impacts on vulnerable nations. So asking the court to clarify these obligations from other sources of international law, including human rights, general principles of international law, customary international law, such as intergenerational equity. According to the CL report, the answer to the question of the courts lies exclusively in the climate regime. The Paris Agreement in particular is essentially lex specialis, or the only source of legal obligations to protect the climate system under international law. Others acknowledge that some international laws apply beyond the climate agreements, contend that the Paris Agreement is the primary source of climate obligations, through which other laws must be interpreted, by which other law may be limited. So COP30, depending on the timing, of course, but the advisory opinion would be informed by the International Court of Justice decision. Galvanise the process, I think that may depend on what degree this is gaps in its functioning. So I hope I've succeeded in giving you a brief overview of the COP process and its links with our concerns. Thank you.
Thank you, Emily, and thank you so much to everyone who's attended in person today and those of you who've joined online on this cold Thursday evening. Everyone will get a link to the slides as well as a recording. It will also be on the Chamber's YouTube channel, so like, comment and subscribe. There's also other seminars and webinars that are on there. This hopefully is just the first seminar in a series of seminars, so please keep an eye out for that. we really appreciate your feedback. We've run out of time in terms of questions, but those of you who are fortunate enough to be here in person, we've got lots of food and hopefully the panel are staying behind. So please do join us afterwards for some food and for some questions. Thank you so much. Thank you. And thank you to the panel.